talking about remedies and reparations, I think that sometimes the problem with thinking about courts and law as a resolution is the extent and the depth and the time frame of the problems. So in many societies in the world where we've been institutionalizing people and forcing them to be in treatment, which has not been good for them and which has been tantamount to torture, we've been doing it for centuries. And we've been doing it without acknowledgement or reparation. So I thought I'd start out by pointing colleagues' attention to Royal Commission of Inquiry on the Abuse in Care, which was conducted in New Zealand recently. And there's a very long report that's been put up on their website in July 2024. And just to give you an idea, so it investigated the situations in abuse of care in state and faith-based institutions for a range of people, not only persons with disabilities, but many persons with disabilities. And the Commission of Inquiry in its report says, it is a national disgrace that hundreds of thousands of children, young people, and adults were abused and neglected in the care of the state and faith-based institutions. These gross human rights violations occurred at the same time as New Zealand was promoting itself internationally and domestically as a bastion of human rights and as a safe, fair country in which to grow up and to live. If this injustice is not addressed, it will remain as a stain on our national character for forever. Now, I think that this could be written in any country. It's not just about what's happened in New Zealand, but it reminds me, and this is something of what I think needs to be done and the type of acknowledgement that needs to be made in Norway as in other places. The degree, the depth, the length, and the severity requires an apology. And Diana might talk a little bit later. The CRPD committee has ordered Mexico to give a public apology to people with disabilities who have been forcibly incarcerated, institutionalized, for basically doing nothing. And I think that when we talk about reparations, we're not only talking about compensation, we're not only talking about cessation of whatever violation has happened, we're talking about a society-wide acknowledgement that the treatment of people has been bad forever and terribly so. When we talk about access to justice, I don't intend to read the article in the CRPD, but there is a separate article on access to justice in Article 13 of the CRPD. One of the reasons why that's there and what it contains in it is because of how difficult it is historically persons with disabilities have found it to access justice. And so the first subsection of this article directs states towards ensuring effective access to justice for persons with disabilities by providing procedural accommodations. Now, what I want to point out there, and it may come up later again, this is the one article in the CRPD which doesn't use the phrase reasonable accommodation, which allows for some flexibility upon the state about when to provide such accommodations and not. And the reason for this is that without unqualified access to the accommodations required for persons with disabilities in the environment of legal processes, it is impossible to participate in a way that is meaningful. And that's very important, because if we want to think about the results that we're getting in courts, and there have been complaints about that, and we've discussed it even in this session, we need to think about, firstly, what is happening in courts and how many people can effectively access justice and participate in processes. The second article directs itself towards basically what the International Commission of Jurists globally is known for, which is providing training and education for judges and lawyers so that they can do the work. And it's no secret that in almost every country in the world, disability in general and disability rights is not well known and understood by judges. Judges even making their best good faith efforts to understand laws, to understand society, and to understand disability might be starting. Many countries, a judge gets appointed at the age of 50, round about there, maybe a little bit earlier, to understand for the first time this range of issues in their lives. And this causes a very big problem, and of course the ICJ advocates for the training of judges and lawyers on the CRPD and disability more generally. We do quite a lot of that all around the world. On access to justice, there are these principles and guidelines developed by the Special Rapporteur, and Alberto, who was here, was working for the Special Rapporteur when those guidelines were developed. There are principles and guidelines on access to justice. If you are working on forced and compelled treatment, it may be that these don't fall within your notice, even if the principles of the CRPD Committee on deinstitutionalization do. But there are many countries in the world in which access to justice and institutionalization or forced treatment are directly connected. Because, as I said, the experiences in courts are often the places where people are institutionalized or are prevented from representing themselves and then become institutionalized and are forcibly treated. And these principles, I can't go through all of them, but their focus, and I think our focus is properly on in this environment, a large range of justice actors. So not just judges, and not just lawyers, but prosecuting authorities, officials within the government, court clerks, all of these. And they focus on the provision of procedural accommodations and ways in which this can be done. I want to emphasize one, which is the role of intermediaries in courts, justice intermediaries, to assist and support persons with disabilities in order to be able to communicate effectively with courts. And here in these principles, again, the training of judges and lawyers is very widely emphasized, because you've got to remember, again, that the judges and lawyers, they're making the decisions that we don't like. The image that lawyers and judges, especially judges, allow for themselves to be taken in societies is sort of like these, philosopher kings and people who are very wise and who know a lot about a lot. But the fact of the matter is that most of the time, because judges work on law of all kinds, when a case comes before them, they don't know anything about the issues that underlie it. And we really shouldn't be thinking about judges as superhuman or incapable of not understanding things. Some general comments that I'd like to make from my experience in working across at least 3 or 4 continents on these issues. Firstly, there's very little work that's done by so-called mainstream human rights organizations on disability rights issues. And this is a very big problem, even in the court. Norwegian organizations advocating for access to healthcare should be advocating against forced and compelled treatment. Norwegian organizations who focus on criminal law and on detention and imprisonment and all of these things should be doing this type of work here. Across the world, this is not done because disability is seen as an issue which is a side issue, and people are left to advocate for themselves, essentially. One of the reasons why I've so strongly advocated within the ICJ for us to do this type of work is because, historically, organizations of persons with disabilities have felt like they have not been of any interest to so-called mainstream human rights organizations, particularly the big ones, Human Rights Watch, Amnesty International, etc. And even then, when there is a focus, it's normally on what are considered to be the most heinous and grossest of human rights violations, which then sort of makes the reporting look like, if you're doing a report on people being shackled to poles in Ghana, like that this is a specific Ghana-related thing. It's not a common problem all around the world. So I think that that's important to look at. And even then, within disability rights, again, it will be no secret here that the focus on psychosocial disability is not very pronounced. And people with psychosocial disabilities are very commonly not very well represented on organizations of persons with disabilities in countries. The evidence of this is substantial everywhere. In Africa, where we work, you have to kind of try and find people to be able to do this work with, instead of finding federations of persons with disabilities who then generally represent the issues and convey them. And yeah, and sometimes even within the ICJ, when the ICJ has been developing standards of a broader nature, and I can give one example. The ICJ published in March 2023 a set of standards on the impact of the criminal law on human rights. And in consultation with colleagues, including Tina, the best that we could do to try and make sure that no harm was done or additional harm was done by these progressive standards was to get our colleagues to remove references to disability and legal capacity from the principles entirely, right? Now, this should show you where we're at, right? Generally, expertise on human rights and you would imagine, sitting where we are and talking about what we're talking about, that like if we're going to develop principles on the application of the criminal law or any coercive forms of detention and human rights, that you would have experts on disability rights in the room, and so you would be able to develop things that were positive. But we have not managed to do that. And so in general, this has been a tactic that we've had to employ several times internally. I just want to talk about the connection between criminal law and petty offences, the criminalization of petty offences, and issues to do with institutionalization. Again, in many countries in the world, and I don't know if it happens in Norway, many of the laws that people are originally in contact with the justice system about when they have any problems related to their mental health is public nuisance laws or petty offences laws that don't allow you to be drunk in public, disorderly in public, causing a nuisance, doing anything that is considered to be antisocial. There's a ridiculous range of this type of law. Some of them are inspired in our countries in Africa by former colonial powers, but in other places, people are perfectly capable of coming up with their repressive laws all by themselves. And once you have committed a petty offense or done something antisocial, you find yourself in the justice system, incapable of communicating, and the court is basically asked, get a psychiatric evaluation and admit this person if the psychiatric evaluation ends up in a certain way. And so there really is this connection between these two areas, and advocating for the change of those criminal laws is a very important thing to focus on as people with disabilities, because they in fact shouldn't exist at all. And those laws represent violations of international human rights law wherever they're applied and whoever they're applied against. The last thing I'll say, and I have to say this about the interconnections, is the relationship between economic and social rights generally and the problem of forced treatment and institutionalization. The reason why in many countries there continues to be institutionalization of so many people is a failure of states to do what they've already agreed to do by providing healthcare, education, housing, social services to people. And if people are provided these services in communities, so if what states have committed to in terms of economic and social rights was done, this problem wouldn't disappear completely, but it would almost completely, there would be a larger extent to which there is no problem here, because people would be able to access services that and I know that in Norway it might be slightly different because there's people who can access services in the community who are being institutionalized, but really advocacy for the protection of economic and social rights in general should be part of our core focus. Briefly, ICJ has recently completed, not published, a study on the laws affecting persons with disabilities in 9 different African countries: West Africa, Southern Africa, and Eastern Africa. And the focus on these laws is also on mental health laws and criminal laws associated with those laws, which I'll talk about a little bit now. By and large, we find the same things that have been spoken about today with the mental health laws. Even where the mental health laws have been amended, supposedly to be in line with the CRPD, those amendments end up entrenching substituted decision-making and allowing for, and sometimes the legislator, I think, thinks that because they're allowing for the power to admit people and forcibly treat them, it's only in very extreme circumstances that it will be used. But when they allow for it, medical professionals interpret this as a requirement too, instead of an allowance for, and then what you end up having is a continuation of the problem that you have had for however long. So that is even laws that on the face of it say that they are existing because the CRPD committee has said you must amend this law, or because this court has said you must amend this law. So this is a very big problem, and legal capacity of individuals with disabilities continues to be perpetuated. An important thing within the justice system is that most of the processes that lead to this detention, whatever they say, and they are different in different places, are routine and not in the formats of proceedings in which there are often human rights experts at all, or anybody who knows anything about disability. And now what I'm trying to say here is that, we might think about court cases as, these glamorous, glorious things with, cameras all around and like very well qualified lawyers making moral speeches about the law and human rights. But what often happens is that the processes that allow for institutionalization or forced treatment happen at the lowest level of the court system. They happen in day-to-day courts, and they happen in front of a judicial officer that has very little time to even look at the law, in front of a prosecutor that is coming across this issue for the first time, right, and a defense lawyer who is a legal aid lawyer paid by the state. So in these type of situations, it's not hard to see how all human rights issues get ignored, including the ones that we're speaking about. Now then it becomes important, right, that we don't think that the general judicial trainings that we do, or if we do them, should just happen with appellate level judges who are sitting on human rights cases. Because the depth of the problem is that to people who are not affected by the issues, the issues are unseen, and it happens in very banal processes within the legal system. One of the things that we have tried to do as the ICJ in working with OPDs all around the world is to try and start advocating for the judiciary itself to set up rules and guidelines. So in many systems, judicial officers have an inherent jurisdiction to decide how their own process works, and that if the government intervenes with it, they are actually impinging on the independence of judges and lawyers. And so judges, because they can do this, and very often the head of the judiciary, whether that's the Chief Justice or a Judge President, can set out practice directives or rules or anything like that. And we've been trying to focus on advocating for these type of rules to be put in place, not only for how procedural accommodations are provided, but how laws, even bad laws like these mental health laws, are implemented. Because while judges can't change the bad laws, they can use the breadth and vagueness of them in a way that is not as bad. And sometimes what you need to do is to get judges to interpret terms like interests of justice in a way that prioritizes provision of supported decision-making instead of substituted decision-making, slows down the process, allows for a person to be properly heard, properly considers whether this person in fact does need to be institutionalized. And I'm not saying that there's anybody who needs to be institutionalized, but even with a bad legal system that requires certain persons to be institutionalized, working in this area with judges and getting them to develop their own rules can be an effective way of trying to curb the problem. Another option is things like judicial bench books, which I already spoke about, to try and implement that.